Questions?
There is a reference, I haven't read all this material, but page 275, where the Court of Appeal upholds the decision to detain, it does say, decided he will continue to be detained in absentia upon suspicion. And then it says the international search and the European arrest warrant will be amended to conform with the detention order. Is that simply recording?
I'm not sure where your lordship's looking.
275 in appendix part 1.
Hard copy.
Do you know what this is? It's a letter.
Maybe that's simply recording something which the prosecution has said, because the challenge appears to be into the arrest warrant and whether there was probable cause.
I'm told this is the prosecutor's website, my lord.
Oh, I see. I see. This is a press announcement.
Yes, it's a press announcement by the prosecutor.
Thank you.
It also says
that illustrates rather neatly the problems if a prosecutor seeks to exercise judicial authority.
Thank you.
It says he should continue to be detained, but at that stage, Lance said he was abroad. All right? Very odd.
Continue to be searched.
What?
I think the reference is to the reduction in the charge. I'm sorry, my lord, I'm at a slight disadvantage not having been in this case below, but...
Yes, actually the decision is 445.
Yes, page 445. My lord.
Yes, that's helpful.
Yes. Yes, my lord, that is... Yes. And your lordship can see that there's no consideration of the sorts of issues that would be relevant to proportionality of an EAW.
In absentia
simply
means ex parte, as I understand it, not abroad. Because if one looks at 447, where there's an application for permission to appeal, the ground is it can be the question of whether it can be regarded as a transgression of the principle of proportionality to issue an arrest warrant for someone because of the danger he will flee, in that he didn't abscond.
Well, he had already left.
Yes, he
Sweden.
had.
There were written submissions put in on his behalf.
Yes. Now, well, then I'm not quite sure what in absentia means, whether it means simply ex parte in his absence.
My lord, I'm not clear. For my purposes, the only point that matters about this is that it simply doesn't address the issues that arise in relation to the EAW.
Thank you. Yes, Ms.
I was going to start with the proposition Ms. Rose regards as being self-evident, that an investigator or a prosecutor cannot exercise judicial authority because they are partial. And I'm going to answer it by drawing attention to this most significant issue, namely that one has to ask that question in a particular context. And the relevant context requires you to consider the circumstances in which power or authority is being exercised. If power or authority is being exercised where adjudication is required between two contending parties, clearly a decision cannot be rendered on that by one of the parties. It must be rendered by an independent, impartial figure. But the difficulty is that the measures about which Mr. Assange complains are not measures which involve adjudicating upon an issue in which there are two contending parties, but adjudicating upon an issue in relation to which the interests of only one party is under consideration. Because what is an issue here is whether there should be an order for the detection and arrest of Mr. Assange with a view to his detention for the purpose of bringing him before a court and subjecting him to a process of extradition. That is necessarily a decision, an adjudication, that will be made almost inevitably throughout Europe by a party, whether it is a public prosecutor or whether it is a policeman.
Public prosecutor or who?
Or a policeman.
Or a policeman?
Yes. The decision whether to arrest somebody normally is made by somebody who might be regarded as being partisan. That's what happens throughout Europe.
We're concerned not only with the question whether to arrest, whether to seek their arrest abroad and to bring them over.
Yes. There are two components. One is the decision to seek arrest. That will inevitably be made by a party. It's not something where any prior independent, impartial adjudication is required, because it's merely the way in which the criminal process starts in almost every case. And that's why Article 5.1, for example, of the European Convention does not impose any obligation upon the person effecting the arrest or seeking extradition to be independent or impartial. All that is required is where the arrest is effective for the purpose of domestic prosecution, that they are then brought before a person who has a power to adjudicate in an impartial and independent fashion. And so the flaw in the whole approach taken by the appellants to this case is they say, well, judicial authority must mean somebody independent and impartial. But the answer to that is not necessarily. If the judicial or the part of the administration of justice that is being invoked and decided upon is in fact the preliminary part, which depends entirely upon the decision of a party, namely a prosecutor or investigating officer responsible for commencing the process of investigation and process. And so there is no reason, if one looks at the exercise of power here in issue, namely the application for somebody to be arrested and taken into detention, there is no basis on which you can say that necessarily must require the decision to be made by somebody who's impartial. The reverse is true.
What do you say the words judicial decision mean? And in particular, what's the word judicial mean? Judicial
means appertaining to the administration of justice. It means associated with the judicial process, but it clearly does not refer to only adjudicative decisions in the sense of final decisions upon an issue joined between parties.
So, I mean, on your interpretation, it's actually a completely unnecessary word. You could strike it out. It's obvious this is all about arrest and surrender with a view to either execution of a custodial sentence already passed or conducting a criminal prosecution. It says so. The word judicial could simply be deleted.
No, I would split it. It plays a role. It demonstrates that the decision must be taken as part of the administration of justice, that it can't be a purely arbitrary decision taken without reference to any judicial context.
Well, can it be taken by a Ministry of Justice?
It really depends upon whether the Ministry of Justice is there exercising a purely executive political role or whether it is exercising some function in connection with the administration of justice. Now, I'll give you a specific example, which I hope will illustrate where we submit the line is to be drawn. Clearly, if we take a ministry